For another installment of Marshall Law, Marshall Chriswell is with us, and this radio program is intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And I think, after reading that disclaimer, Marshall, that this would particularly apply to the issue of the day today, which is, say you've gone and you've had work done at mechanics or some other contractor, and you haven't paid your bill. What is the legal recourse for that contractor in your case? Can they just slap a lien on everything that you have and say, you don't get anything until I get mine?
Yeah, it's a great question. And in Pennsylvania, there is what's called the mechanics lien law, and it applies to situations where general contractors, subcontractors, even subcontractors that have done work on real estate and allege, okay, I've done my work, I've finished my job, but I haven't been paid. Either I haven't been paid in the case of a general contractor by the homeowner or property owner that I'm doing work for, or in the case of the subcontractor or even subcontractor, they say, well, the guy ahead of me, the general contractor got paid, but he didn't pay me. Mm-hmm. So the mechanics lien law permits those entities to file they have to file a notice first, and then they can actually file a lien on that property. Okay. And so it is limited to the property that they perform the improvements on. Okay. The law is very narrow as far as what kinds of work can be that you can file a mechanics claim on. It has to be something that was to improve the property, so new construction, an addition, a remodel, things like that. And there are very specific procedures to follow to get the lien. But bottom line is, if a contractor or subcontractor doesn't get paid, they can, like you said, slap a lien on the property and say, okay, either I need to be paid now, or if this property's, if you're planning to sell the property, it's got to be that lien is going to have to be satisfied before it can be transferred. So it's a very powerful remedy. And it gives the contractor or subcontractor, as the case may be, a lot of leverage to get paid.
Can the sub leapfrog over the general contractor and go right to the property owner?
The subcontractor can put a lien directly on the property, and in a lot of cases, what happens is then the general contractor, especially if the entire project hasn't been completed yet, they're then under a lot of pressure to make sure that subcontractor gets paid, so that they can continue to get paid from the homeowner or property owner and continue the work. Yeah,
you wonder about situations where that property owner gets the lien slapped upon them. They say, well, wait a second, I paid the general contractor, and that should wipe my bill out. I paid everything that I was owed to the general contractor. Why are you now coming back at me?
And that's where a lot of problems arise. If you have a general contractor who has fallen behind, has robbed Peter to pay Paul, has not paid out his subs as per the contract, and what they're entitled to pursuant to the work they've done, then you have a homeowner that's saying, "Oh man, all right, now I've got to sue my general contractor because to eliminate this problem."
It can get pretty tangled up, can
it? It really can, and it just it really speaks to a couple of different issues that we've kind of talked about in the past in a few different segments. the idea, number one, of doing your due diligence and knowing who you're doing business with. As a homeowner or commercial property owner that says, all right, I want to get some work done on my property, whether it's for your own personal enjoyment or because you want to sell the property. Knowing who, getting good contractors that come with good recommendations, maybe even doing a little bit of research to see, has this particular contractor been involved in a lot of litigation? Certainly, you can do a criminal background check. Sure. All kinds of things to make sure that who you're doing business with, because that can avoid some issues. And then having detailed written contracts is super important. So there are ways to mitigate the risk.
I'm interested in the title of the law, the mechanics lien. Did it come out of automobile mechanics issues and then be extended to general contracting as a whole?
I don't think so. I don't actually know the etymology of that term, that legal term, mechanics lien, but I think it's a very, very old term, and maybe that even predates cars. So, but it's interesting. There are laws as well, and in Pennsylvania there is case law that gives vehicle mechanics the right to have their own kind of lien, where they can actually what their remedy is they can hold your vehicle.
Yeah,
they can legally hold your vehicle, and they don't so they don't have to go through filing a lien with PennDOT or something like that. They can actually hold the vehicle and say, hey, you're not getting it back till I get paid. And I've litigated those cases as well.
And not exactly that issue, but beside that issue is towing companies who tow and then impound on a lot, and if they don't get paid, they don't release it. And sometimes you hear of people getting arrested for jumping the fence and taking their second set of keys and then ramming through the fence, or however it is that they get out, trying to steal their car back
That's right.
from the tow company. And that's, it's all a part of paying for services. And what are the legal recourses if people do not?
Yeah, and these laws, whether you're talking about real estate or motor vehicles, it's a really powerful, like I said, a really powerful remedy for the service provider, because they're basically getting to, they get the initial the initial shot across the bow. They get to say, okay, we're going to put a lien on the property. All right, if in the case of real estate, there may be disputes. All right, it might not just be that your contractor just didn't get paid because you decided not to pay your bill. It could be that the work isn't done. It could be that the work is done, but you don't think it was done in a workmanlike manner. It's just not up to snuff. There can be lots of reasons. The job may have been delayed for the past 6 months, and your contractor just kind of disappeared, or he shows up in stops and starts, and you're saying, okay, well, I'm not going to pay you until you actually do something here. And then the contractor has this very powerful remedy and all this leverage to say, all right, we're going to come in and place a mechanics lien on the property until I get paid. And you have all these other issues that have to be resolved. But then all of a sudden you're in court, and that gets very expensive. So it's they're interesting situations.
So when people get involved with you, which is generally after the legal action has been initiated by another party, what are the things you recommend? I would assume good record keeping is right there at the top of the list.
Yeah, we initially want to get I want to see the contract. If there is one, and in too many cases there aren't. I want to see every invoice for both sides, whether I'm representing a contractor that hasn't been paid or a homeowner that has had a lien placed on their property, or whatever the issue is. I want to see every invoice. I want to see all the checks, copies of proofs of payment. Hopefully, you haven't been paying somebody in cash. We want to see proof of payment. And then we want to talk about, okay, what was the actual scope of work here, and what are the issues that you're having as far as why payment hasn't been made or whatever it is. But all that documentation is important, particularly in these. We're talking about these mechanics liens cases. You want to act quickly to try to get the issues resolved, because you don't want a lien on the records, particularly if you're trying to turn around and sell this property.
And it's always a good idea to have a signed document ahead of time that's going to line out everything that is anticipated, the agreement itself, and to have read it. I think people don't actually read what they're signing a lot, and they could avoid a lot of problems.
Yeah, that's right. Read and reviewed by legal counsel. I mean, it's just, I can't say it enough. But yeah, a very specific scope of work and how what the terms of payment are going to be. Is this going to be a job for a lump sum, or is it going to be an hourly? Are they is the contractor going to work on an hourly rate? Is it a time and materials job? How's that going to work, and how often are the payments going to be made? Often there's a schedule of draws that the contractor will obtain over a period of time. And how are we going to know? Let's specifically set forth in the contract. Okay, when are those going to happen? What has to be completed for the next payment to be made? And those are all things that really need to be set forth.
All right, here's the curveball I throw at you. Are you satisfied as an attorney that the law is fair toward one side or the other, toward the contractor or toward the property owner? Is the law balanced between the two fairly?
I think that it is. I think that I think it's really important to be able to give service providers, like contractors, the right to be able to seek payment whenever they're performing improvements at a property that's increasing the property's value, particularly where it's going to be going up for sale. And once and to give them that leverage. I think the issues that arise are where there are disputes about, like I said, whether the work was done properly, whether the work was completed at all, and sometimes it's just in those situations, sometimes a homeowner or property owner can kind of be put behind the eight ball, but I do think that there's balance there.
All right, very good. People want to learn more. People might have a case that they want you to review for them. What do they need to do?
Give me a call at 724-465-5826. Stop in to see me in the Atrium Building, downtown Indiana, or online at westernpalawyer.com.
He is Attorney Marshall Chriswell, and it is Indiana in the Morning, presented by First Commonwealth Bank on the Voice of Indiana County, WCCS, AM 1160, 101.1 FM.